Let's bring in former acting U.S. Attorney General and host of the Liberty and Justice podcast and the author of the Above the Law, Matthew Whitaker. Matthew, we appreciate you being with us. Obviously, let's start with the affidavit here. What stands out to you?
Well, the heavy redactions is really what stands out. If you think about what we knew about this case, we don't know really much more than we started with. And really much of what we've learned leading up to the release of this redaction was through leaks from the Department of Justice, which are just absolutely shameful. But, you know, I think that this document was purposefully heavily redacted so that on the one hand, they could claim they were giving transparency and that they had released this affidavit, and on the other hand, not providing anybody with any real information to know what this investigation is about and where it's going.
What have we learned from this document?
Well, we've learned that there's a chronological outline, if you follow sort of what is revealed, that an investigation started after these boxes were recovered in January. The FBI came in sometime in the spring and decided that there were significant classified information in these boxes, and therefore they should open up a criminal investigation. And then they sort of dawdled for months, including the Attorney General of the United States, on his review of the search warrant application. He took weeks to decide, and then after the search warrant was granted, they still took a whole weekend off before they went and grabbed these documents. But from what I can tell, this is just a disagreement about possession and control of documents. And, it's really disappointing that the FBI and DOJ couldn't find a less intrusive way to get these documents if they believe they should have them.
Yeah. And if you were advising the former president on this case, what would your takeaways be in terms of their legal strategy moving forward here?
Yeah, well, I try not to give free legal advice on television, but I would tell him that, he needs to continue to press for transparency from the Department of Justice. He needs to continue to outline the traditions and the law in this space and make sure that the public perception is not changed. The fact that, there are just a couple things that are very basic and need to be understood. One is while President Trump had the ability to declassify any and everything. And second, the classification system is for the benefit of the president and the executive branch, and he doesn't have to be a servant to that while he was president. So I think there is a lot of stuff that's still going to be sorted out, but those are the fundamental bases that I would not relent on, if I was providing free advice.
When Trump said in his statement there that Judge Bruce Reinhart should have recused himself from the case, having dismissed himself from a previous case, should he have?
Yeah, each judge obviously is responsible for their own recusal analysis. He did an analysis in a previous litigation involving Trump, and in this litigation, he's not doing the same analysis. I don't know what his analysis was, and that's the challenge, because these judges get to make up their own mind, and they don't have to share it publicly. And so I don't know what his conflict that required him to recuse, but it would seem, since Trump is a party in both litigation, that there would be a bias towards recusing. But in this case, unless he provides a public explanation, it's really hard to tell.
And we know that Judge Reinhart had previously released the search warrant, the application rather, for the search warrant detailing potential crimes, including the willful retention of national defense information, concealment or removal of government records, and obstruction of a federal investigation. In terms of how all of this pertains to the Espionage Act, that clearly states in that statute that it is simply the willful retention of documents or classified information, and it's refusing to hand that over to the officer in charge. There's been a lot of talk and maybe confusion about people saying that there has to be intent there, but there really doesn't have to be in order for him to be brought up on that charge.
Yeah, well, there's mens rea, which is the willful. So I mean, there has to be some mens rea attachment. It's not a strict liability crime, and I still think the first hurdle, based on everything I've read and looked at in this case, is whether or not these documents were classified at the time. Because remember, there have been several allegations made by people in the national intelligence community that with direct discussions with President Trump at the time, who he said that certain types of documents and certain documents that were taken to the residence were immediately declassified. And so I just, I continue to think that this case is all about getting the documents in possession of the government. And I really don't think they have a desire, nor do they have the evidence or the mens rea to charge anyone, like especially President Trump, with crimes.
Matthew Whitaker, we appreciate you being with us. Thank you.
Good to see you. Have a great day.